General, is
Counsel, your friend on the other side said that your position would require religiously affiliated hospitals with emergency rooms to perform abortions. Was he right?
No, my friend was wrong. There are federal conscience protections that apply at the entity level to hospitals as well. The key provisions are in the Weldon Amendment and also Coate Snow, although that depends on the residency program of a particular hospital. Now, HHS said in a 2008 rulemaking on conscience protections that it had never come across a hospital that had a blanket objection to providing life-preserving and health-preserving pregnancy termination care. But if a hospital had that kind of objection, and HHS recently informed me they still have not come across that hospital, that would be honored vis-a-vis HHS's enforcement ability.
You said that applies at the entity level. Can individual doctors in the emergency room, do they have a conscience exemption?
Oh, yes. Yes, they're protected under the church amendments principally. And our position is that EMTALA does not override either set of conscience protections. So if an individual doctor has a conscience objection to providing pregnancy termination, EMTALA itself imposes obligations at the entity level, and the hospital should have plans in place to honor the individual doctor's conscience objection while ensuring appropriate staffing for emergency care.
Does that mean that there must be somebody in the emergency room that can provide an abortion? What if there are 2 doctors, 3 doctors, and they all have a conscience exemption?
No, in that circumstance, EMTALA could not override those individual doctors' conscience protections, but my understanding is that as a matter of best practice, because hospitals want to be able to provide emergency care, they do things like ask doctors to articulate their objections in advance so that that can be taken into account in making staffing decisions and who's on call. Hospitals have a lot of plans in place for these kinds of contingencies.
Yeah. Are you saying that there must be somebody available and on call in a hospital of that sort?
The conditions of participation for Medicare require hospitals to be appropriately staffed to provide emergency treatment. Now, in a situation where a hospital hasn't done that and it doesn't have anyone on hand who can provide care, maybe all of the doctors called in sick that day and there's just literally no one in the emergency room, or in this case, if everyone had a conscience objection, then the hospital would not be able to provide the care. But there are conditions of participation that are meant to ensure that there is good governance of hospitals and organization to account for these situations.
And the consequence of them not being able to provide the care would be what?
In that circumstance, I think they would likely be out of compliance with the conditions of participation that require them to be appropriately staffed. But if the question is, could you force an individual doctor to step in then over a conscience objection, the answer is no, and I want to be really clear about that. We don't understand EMTALA to displace it.
Excuse me. The question is whether or not they must have available someone who can comply the procedures required by EMTALA. And what would be the consequence if they didn't? Would it be eventual termination of their participation in Medicare?
That's right. So if a hospital was continually disobeying the requirement to have in place sufficient personnel to run their emergency room, then I imagine that HHS would, through enforcement action, work with that hospital to try to bring it into compliance. And if the hospital ultimately is just leaving itself in a position where it can never provide care, then it would terminate the Medicare funding agreement.